Are you a new applicant for deferred action for childhood arrivals or DACA? Did you know that the final DACA rule will soon allow new applications to resume being processed? Hi, my name is Andre Major, immigration attorney and an immigrant myself. In today's episode, I will discuss some updates on the new final rule for DACA published by the Biden administration just the other day and how these rules are going to affect you. Before I begin, please click the subscribe button below and the notification bell to keep up to date on all of our latest immigration content. Also, if you have comments or thoughts about today's video, please share them below. Let's get started. The new final rule for DACA will codify and fortify the program originally enacted only through an executive order in 2012, so 10 years ago, by former President Obama. As you may know, the program has been up against many lawsuits, the latest of which prohibited the granting of new DACA applications, but allowed the renewal of existing applicants. Now, the current administration has finalized a new rule that will once again allow the Department of Homeland Security to process new applications for DACA. This rule is going to take effect October 31st, 2022, provide no other legal disputes arise. Let's look at this final rule. So update number 1, 2012 DACA eligibility requirements are the same. They did not change. The new final rule retained the initial threshold criteria of DACA since its implementation on August 5th, 2012. The final rule says, in order to apply for DACA, you must have come to the United States before you turned age 16, that you must have been under 31 years old on June 15, 2012. So basically you were 30 or less. You entered the US either without inspection, meaning illegally, or you overstayed your visa and that visa expired before June 15, 2012. You were inside the United States on June 15, 2012, and you've lived in the U.S. continuously since 5 years before the program was created, was enacted, or June 15, 2007. You are currently in school, you've graduated from high school, received a GED, or were honorably discharged from Coast Guard or U.S. Armed Forces. Basically, either you're working towards a high school degree through GED, or you already have graduated high school. If you're in college, it means you've had either a GED or a high school degree, in which case you've already satisfied this criteria. And you have not been convicted of a felony, through a significant misdemeanor, or 3 or more misdemeanors of any kind. And lastly, you don't pose a threat to national security, public safety. Update number 2. Filing employment authorization is now optional. The proposed policy originally planned to change the process of DACA by making the request for employment authorization on Form I-765 optional. However, in the final rule, it retained the requirement of filing the work authorization concurrently with a DACA application. But it clarifies that work authorization is terminated when your DACA status ends, rather than having it upon the mere commencement of removal proceedings against you. So there could be a situation where your work authorization is terminated, but your DACA is still valid, or it expired, meaning your work authorization is expired, even though your DACA status is still valid. It's not required that you have both. Update number 3. Those with DACA status are considered lawfully present. The final rule considers those granted deferred action as lawfully present. Now, it doesn't actually give you lawful status. Again, it can't do that because only Congress can do that. But however, it does help you to not accrue unlawful presence. So although it doesn't give you lawful status, you're not accumulating unlawful time. Does that make sense? I know it's confusing. It doesn't give you lawful status, but it prevents you from getting, so it doesn't give you a good, but you're not getting a bad. Update number 4. Certain offenses do not automatically disqualify for DACA. DHS clarified that expunged convictions, juvenile delinquency adjudications, and immigration-related offenses such as felonies or misdemeanors do not automatically disqualify you or automatically make you ineligible for DACA. Update 5, USCIS retains the termination of DACA upon its discretion. The final rule makes clear that USCIS, in its own discretion, can terminate DACA with the issuance of a notice of intent to terminate, or NOIT. The same applies to those who left the U.S. without advance parole and then re-enter without inspection. They can terminate automatically. However, to those convicted of national security offenses, their DACA status may be terminated even without a notice of intent to terminate. Keep in mind, DHS clarified existing recipients do not need to request for DACA again under the new rule to retain their initial grants. Nice and confusing, right? What on earth does that mean? Well, if you have DACA and the next year flying to renew, you're not filing a new initial application. And that summarized the updates of the new final rule for DACA that would be published soon and will come into effect on October 31st, 2022. If you're a new applicant of DACA and are confused on what steps to take or uncertain of your eligibility, leave a message below or schedule a consultation with us at our website, andesmeckerlaw.com, or give us a call at the number that you'll find below. We're here to guide you through your journey to get a visa, a green card, or become a U.S. citizen. If you find the video helpful, please share it with friends and family who might be considering filing for DACA or a visa, green card, or citizenship. Lastly, if you have any ideas for future subjects and you'd like me to talk about something in particular, let me know below, and you might see it in an episode in the very near future. Thank you and take care. Stay healthy.